Hi there. Today I want to talk to you about a COVID travel ban case that is headed to the Supreme Court of Canada, and we at the Canadian Constitution Foundation will be intervening in it. No, this is not the Brian Peckford challenge to vaccine mandates for air travelers during the pandemic. That case, the Supreme Court did not hear. This is a different case, and it's called Taylor and Newfoundland. And it's about whether or not we have any right to travel between provinces in Canada at all. This is called the right to mobility simpliciter. So you're not moving to another province to relocate there permanently. You're not moving to another province for a job. You're just going to another province for, like tourism or just to visit someone or just for whatever reason you want, basically. And I think that, yes, of course, you have this right to mobility. It is clear in the text of the Charter and from the history of Canada pre-Charter that this right exists. But for some really bizarre reason that I'm going to tell you all about, the Newfoundland government thinks no such right exists at all. Well, we are intervening in the case to argue that the government is wrong. Yes, there is such a right, and the court should uphold that this is a constitutionally protected guarantee we have in Canada. I can't wait to tell you all about it. If you're new here, welcome. My name is Christine and I'm the litigation director with the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing legal cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you would be interested in, please hit like and subscribe below. It really helps my videos out a lot by showing them up in the algorithm. It promotes the videos more if you engage with them. So leave a comment, let me know what you think, like the video, hit subscribe, help me out, do your part to advance freedom in Canada by hitting that button. Also, please remember that nothing in my videos is ever legal advice. If you have your own legal question or problem, please consult your own lawyer. Okay, so let's talk about this case, Taylor and Newfoundland, which is headed to the Supreme Court of Canada. And I am so excited that it is. I think that this is the first time that the constitutionality of a COVID era restriction is going to be considered by our top court. So first, let me give you some background. As we all know, in response to the COVID-19 pandemic, governments in Canada and around the world started implementing public health measures of various degrees of extremeness. We all remember these. I think we probably all wish that we didn't. We wish we could forget them, but it actually is really important to remember what happened. So the government of Newfoundland and Labrador, they took some pretty drastic steps. And one of them was to restrict entry into the province entirely. They used a piece of provincial legislation called the Public Health Protection and Promotion Act, the PHPPA, and the Chief Medical Officer of Health in Newfoundland used the PHPPA, specifically a section called Section 28, to make an order restricting travel to Newfoundland. And using that legislation, the chief medical officer issued this order that prohibited anyone other than residents of the province, asymptomatic workers, or people who had received an extenuating circumstance exemption. Anyone but those groups were prohibited from entering Newfoundland in early 2020. Now, Kim Taylor was a woman who lived in Nova Scotia and her mother lived in Newfoundland. And her mother suddenly and tragically passed away. And Kim Taylor, of course, wanted to travel to Newfoundland so that she could go to her mother's funeral. So she applied to come to Newfoundland using that extenuating circumstances exemption. And she waited for a response for the government. And as people did back then, she made all of these plans to have a special place for her to stay where she could do this government required 14-day self-quarantine in Newfoundland. But she didn't hear back from the government. So she sent a follow-up email and was then informed that the government was denying her request to enter Newfoundland under an extenuating circumstances exception. And I mean, that's just unbelievably cold and cruel and terribly bureaucratic. And I think demonstrates a lot of the problems that we saw during the pandemic in in really vivid and depressing color. So Kim had been denied access. She was upset, obviously, and she asked for a reconsideration. And eventually the government of Newfoundland did grant her the exemption. They reconsidered her case and they said she could come to Newfoundland. So she was eventually able to get to Newfoundland. But what happened to her wasn't right. And she decided that, along with the help from another civil liberties group called the Canadian Civil Liberties Association, she was going to challenge that law, Section 28 of the PHPPA. Together, they brought this legal challenge and they made a number of different legal arguments, but I think the one that's interesting for the purposes of this Supreme Court case is she made an argument about Section 6 of the Charter, which protects the right to mobility. And basically, it protects the right to mobility in two ways. Section 6 sub 1 of the Charter guarantees the right to enter, remain in, and leave Canada. And Section 6 sub 2 of the Charter guarantees the right to move to and take up residence in any province. And the Newfoundland court found that her Section 6(2) right, which is the right to move to and take up residence in any province, that was not engaged. They said she wasn't trying to move to or take up residence in any other province. They said that she did have a right, though, under Section 6 sub 1 of the Charter, which was her right to enter, remain in, and leave Canada. Now, I actually think that the right to mobility simpliciter could probably be found under either of these two rights, but the Newfoundland court said it was under 6 sub 1, not 6 sub 2. But after finding that her right was violated, they found that the limit on her right was justified under Section 1 of the Charter, which allows the government to put reasonable limits on our right. Everyone was basically upset with this case. The government was upset because they don't think there is a right to move between provinces at all. There is no right to mobility simpliciter. They think that does not exist under Section 6(1) or under Section 6(2). And obviously, Kim Taylor and the CCLA, they think that there is a right to mobility simpliciter, whether it's under 6(1) or 6(2), and that the limit on her right wasn't justified. So what happened next was a little bit unusual because everyone was unhappy with the result of this case. The CCLA and Kim Taylor, as well as the Newfoundland government, they all appealed the case. No one liked the result, so they all tried to appeal. But in August of 2023, the Newfoundland Court of Appeal said that they weren't going to hear the appeal because the case, they said, was moot, since the pandemic, obviously, at that point was over. But everyone still wanted it heard, so they appealed to the Supreme Court, and the Supreme Court has agreed to hear the case. And I'm glad that they are hearing it because this is one of the few opportunities to consider these COVID-era restrictions. And it was a little bit of an unusual outcome to find that there is a right to mobility between provinces under Section 6(1) of the Charter, but not under 6(2). As I said, I think it could be under either, because I think at its core, Canadians have the right to move within their country. And this case, what it's going to do is determine the scope of that right. They're going to consider the source of the right, whether the right exists at all, and where exactly in our Constitution it's guaranteed. And this is good for individual freedom because we want clear judicial guidance on the scope of the right to movement. So what Kim Taylor and the CCLA are going to be arguing is that the lower court made a mistake in their interpretation of Section 6(2) of the Charter. That's the part of the Charter that guarantees the right to move to and take up residence in any province. And they're arguing that the interpretation is too narrow, that the right to mobility simpliciter does exist under Section 6 sub 2. And as evidence of that, they rely on the French language text of Section 6 sub 2. They're going to talk about prior judicial consideration of Section 6 and which includes pre-charter jurisprudence on the right to mobility. And they're also going to be talking about academic commentary on the minimum content of Section 6. So the French language argument that the CCLA is bringing is actually pretty compelling. It's a really interesting argument, and it's important to know that the French and English texts of the Charter are equally authoritative. So they both have the same weight. And I'm going to put them up on the screen here so you can see the difference. So as you can see, the French language says under Section 6 sub 2 that Canadians have the right de se déplacer dans tout le pays et d'établir leur résidence dans toute province. So in the French version, de se déplacer means to move in the sense of to getting around or to travel. So the direct translation of the French text of Section 6 sub 2 is basically to get around and travel through the entire country. So there's actually a specific French word, déménager, for the concept of moving in the sense of changing residence. So if the drafters of the Charter were meaning to protect only the right to move to relocate to any province, as in take up residence there, they would have used the word déménager instead of se déplacer. So I think that this shows that the purpose of Section 6 sub 2 was not just to encourage economic integration, but to enshrine the freedom of movement and equal treatment regardless of province of residence as fundamental human rights for all Canadians. We at the CCF have been granted intervener status to intervene in the appeal at the Supreme Court on the issue of the scope of Section 6 of the Charter. And our intervention is going to be all about how Section 6 of the Charter is informed by other provisions of Canada's Constitution and how the Constitution needs to be read as a whole. The Supreme Court has held in previous cases that the individual elements of the Constitution are linked to the others, and they need to be interpreted by reference to the structure of the Constitution as a whole. For example, in the Senate reform reference, the Supreme Court asserted that our interpretation, understanding, and application of the Charter must be informed by the assumptions underlying the text and the intended interaction of the constitutional provisions. And we're going to be arguing that there are provisions of the Constitution Act 1867 and other provisions of the Charter that support that there's a right to mobility simpliciter, to travel between provinces. For example, the preamble to the Constitution Act 1867 states that the provinces express their desire to be federally united into one dominion, and the Supreme Court has on multiple occasions reaffirmed the intention of the Constitution to create a unified country. In the Quebec secession reference, the Supreme Court has stated that the vision of those who brought about this confederation was to create a unified country, not a loose alliance of autonomous provinces. So in this context, the right to interprovincial mobility, the right to travel between provinces, would realize the founding provinces' desires to be a federally united country into one dominion. And this is an organizing principle of the Constitution that is affirmed in the preamble and recognized by the Supreme Court. Now, that's all pre-charter. And when you consider the Charter, that's also important as well. So Section 3 of the Charter deals with voting rights, and the Supreme Court has held that the right to be a candidate and to sit as a member of parliament or in a legislative assembly should be interpreted broadly. So citizens nationwide are all entitled to membership in the House of Commons if elected, which Section 5 of the Charter makes clear requires sitting in Parliament in Ottawa. So this would, of course, require travel to Ottawa. And while Section 6 sub 2b makes it clear there's a right to pursue the gaining of a livelihood in any province, participating in democracy as a member of Parliament entails more than gaining of a livelihood. It's participation in our democratic process. And without a right to mobility simpliciter, there would be no right to travel to Ottawa, the seat of our democracy, as a citizen. Section 24 of the Charter also allows anyone whose freedoms have been infringed or denied to apply to a court of competent jurisdiction. And the Supreme Court is, of course, the top court in Canada and meets that criteria. And this implies that claimants who want to have their case heard would need to travel to Ottawa to be heard in front of the Supreme Court in order to exercise their rights protected under Section 24 of the Charter, which entails, unless they live in Ontario, the need to have a right to travel to Ottawa. And that's not for the gaining of the livelihood or the relocation to Ottawa. It's to exercise your other constitutionally protected rights. Now, additionally, Section 91 of the Constitution Act 1867 outlines the federal government's powers and responsibilities, specifying areas where federal parliament can legislate. And many of these areas inherently require or they presuppose a right to interprovincial travel. For example, the Postal Service, military, ferries, local works and undertakings. Sections 91 and 92 of the Constitution Act set up a country that appears to presuppose interprovincial mobility. And the enactment of the Charter and Section 6 of the Charter would not operate to derogate from that right to mobility simpliciter. There's also a pre-charter decision, a case called Winner and SMT, where the court held that a province could not bar a Canadian from entering it unless perhaps there were certain temporary circumstances like health. I mean, that could engage Section 1 questions, but certainly it presupposes that there is a right to mobility simpliciter that predates the Charter. So I think that Canadians have the freedom to move within their country, and this case, Taylor and Newfoundland, is going to determine the scope of that right. And it's interesting to me that both the government and Miss Taylor and the CCLA, they all wanted this case appealed. The legal questions in it are really fascinating, and the court is going to consider, as I said, the source of the right and if it exists at all and where in our Constitution it's guaranteed. And I think that this is so important for the principles of freedom and liberty in Canada to have clear guidance on this. But at its core, it's also so important to remember the facts of this case. Kim Taylor wanted to go to her mother's funeral. The Newfoundland government imposed travel restrictions that prevented her from traveling to the province where that funeral was being held. The restrictions had an exemption for extenuating circumstances, and she was at first denied, even though her circumstances were clearly extenuating. When Ms. Taylor and the CCLA challenged the restrictions, the government argued that the Charter doesn't even guarantee the right of people to move within provincial borders, which is clearly contrary to the notion of a single unified nation and rights that predate the Charter. Ms. Taylor wanted to travel for compassionate reasons, to go to her mother's funeral, as any reasonable daughter would want to do. And I think that her story resonates with a lot of people who were denied access to their loved ones by arbitrary, irrational, and heavy-handed government measures during the pandemic. And now the government's trying to use that justification to redefine the meaning of our rights today. And we need to push back against this. So we actually wrote about Kim Taylor's story in our book, Pandemic Panic, that does a deep dive on everything that happened during the pandemic to our civil liberties and the legacy that it's going to have on our fundamental freedoms forever. You can get it on Amazon. I'll leave a link to it below. We were actually nominated for Canada's top prize in public policy writing for it. So if you did read the book, thank you. And please let me know in the comments below what you thought. And let me know what you think of this case. Do you think that there is a right to travel within Canada? I mean, I think it's pretty clear in the text of the Charter that there is. What do you think of the Newfoundland government's argument that there is no such right? Leave a comment below and let me know. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.